We will call the first case, Danhoff versus Fahim. This is a 15-minute mini oral argument on the application. Welcome, counsel. You may reserve some of that 15 minutes if we do not use it up, and we ask that you do your best to keep track of your time. And you have 2 minutes of a free fire zone if you wish.
Thank you, Your Honor. My name is David Parker. I represent plaintiff Appellant, the Danhoffs. I would like to reserve 3 minutes for rebuttal. This appeal, this oral argument, brings to the court 3 interrelated questions dealing with the narrow but important area of expert qualification in medical malpractice cases. And the questions are, I'll go in reverse order, I think. Was this expert sufficient? Did he present sufficient testimony and backup such that he should have been allowed to testify in the upcoming jury trial? The trial court said, no, you need direct literature to support a standard of care opinion in this sort of case. And the Court of Appeals affirmed using that exact syllogism. You need direct literature support. That has never been a requirement of Michigan Daubert law. And even Ehler and Edry did not go that far as to say that it must always be published peer-reviewed literature in support of a standard of care opinion. Instead, what you need is the kind of flexible approach that most jurisdictions, including the federal courts, take as to Daubert. In other words, no one factor necessarily predominates. It's the facts of the case and the expertise of the expert, which then integrate any supporting materials or opinions into that expert's opinion. Literature does not speak for itself. It must speak through an expert, and that's what this expert, Dr. Kobe, did.
If reliability is the whole point behind Daubert,
correct.
What is the harm in suggesting that a good place to be looking is peer-reviewed literature, so that we have some sense of that this opinion is substantiated in the medical community? If that's not the basic first step, then what is?
The basic, well, we'll start with there. There is nothing wrong with the suggestion that peer-reviewed literature is a good avenue of support for an expert opinion. But in many cases, including this one, there is not direct medical literature saying that what defendant Dr. Fahim did was contrary to the standard of care. That simply is not how medical literature works.
I guess the point is, why isn't that a problem?
Because it's a problem because lower courts are striking experts based on the absence of literature.
Why isn't that a problem for your case? If there's no literature out there, no peer review, nothing to say this was a breach of the standard of care, shouldn't that be a problem for you?
No.
Why?
Because it's not a problem anywhere else. This court does not erect barriers under the Daubert analysis to the introduction of expert opinions. It vets experts' opinion based upon that field's practices and procedures. This is a man who has done this procedure. His experience has taught him that this is wrong. He then found medical literature.
Is there anything in the record to validate his experience that would substantiate this opinion?
Correct.
Is there anything in the record other than his claim that I'm experienced and I know it and I've seen it 100 times? Is there anything else that would validate that would suggest that this is reliable?
Yes. His basis for doing so was the same basis on which the defendants brought in experts in the Ehler case. They checked, they compared statistical analysis. They say, well, how often does this happen? How often does this happen? Because not all complications of surgery necessarily happen absent a breach of the standard of care. Some happen with a breach of the standard of care. Some happen without a breach of the standard of care. How can we tell the difference? We need an expert witness. This expert witness is the kind who's done this procedure and has gone and taken it upon himself to say, this particular complication from this particular procedure is not an acceptable known complication of surgery. I think that's good enough. It should be good enough under Michigan law.
Counsel, in this case, was the expert rejected solely because of the lack of supporting literature, or were there other factors?
That was the principal factor relied upon by the trial court.
What about, didn't the other side present affidavits that conflicted with his viewpoint?
No, the defendant submitted some material, but the court did not consider it either in the original motion or in the motion for consideration. It was solely based upon plaintiff's expert's testimony, and on the reconsideration, he submitted the affidavit, which is set forth in Exhibit N in our appendix, stating why he arrived at that testimony and what supported him in that testimony. In his deposition, in fact, he said, I do not have the articles with me, but I've looked at articles, and I believe this is an unacceptable complication of surgery.
And I think, am I correct that the articles sort of outline how the surgery should be done and how to avoid problems?
That was the intent of it. I'm not sure exactly how, I'm not intimately familiar with that particular article, but it was definitely touched upon. I don't know in how depth it was gone into.
Okay, thank
What
you.
was the article peer-reviewed?
What?
Was it peer-reviewed?
I'm not sure. These were a statistical analysis, so I don't know whether peer review applies to statistical analysis or not. I do not know of any requirement that peer review is necessary when an expert relies on literature. I think these are undue barriers which are being erected improperly only in Michigan to the detriment of Michigan plaintiffs.
What does the fact that the complication is rare have to do with whether or not it's a breach of the standard of care? Your expert seems to connect those two. He doesn't point to any support anywhere for that, so we just have to rely on his
Correct.
intuition that
No,
something that's rare.
It's not
Is
intuition.
negligence?
If there is a known complication of surgery, it happens. For example, let's use the
Well,
common
this
clipping of the
this is a known complication because he can identify statistically from studies how
Correct.
often it occurs. So
Correct.
it's known, but
It's-
it's rare. So
Right.
why does the fact that it's rare mean that it's the result of medical negligence?
It means that it does not happen often enough that it is known among the community that it has to be avoided. In other words, with a common bile duct, you have trouble with visualization. You have trouble with, they explained why it was difficult. Here, Dr. Fahim did not explain that, and in fact, Dr. Fahim testified that this never should happen. So now our expert says, well, this never should happen, and in fact, it happens so rarely that it can't be a common occurrence and therefore a thing that must be overcome because the surgery is so helpful that we must put up with the complications of surgery. This one is so rare, it should not happen in the absence
So
of medical
only-
negligence.
I'm
it
just
is
trying to
his-
understand what the connection is. Like,
It's
is there
his
some-
experience and skill and knowledge
No,
that
it's
makes
not-
that connection.
The connection is, if something happens rarely, why is it more likely to be a breach of the standard of care? I'm just thinking logically.
Yeah,
It
but
could be just, things are complicated, and there's a lot of different things going on in the body, and different problems arise, right? There's a lot of interrelated organs and tissues and things that are happening, and so,
let's get philosophically, everything that happens in medicine is a known complication unless it happens for the first time. In other words, if you give 50 milligrams of this instead of 5 milligrams, there's going to be a bad result. But nobody seeks to excuse that behavior. Well, this is a known complication. You give too much drugs, a person gets sick and dies.
but some things are accepted as part of the standard of care, right? Some complications
Yes,
are accepted.
yes, our expert has testified as such.
And what
But
I'm
this
trying
is
to
not one of them.
What I'm trying to understand from you and from your expert is why does the frequency or rarity of the complication, what does that have to do with whether or not it's a breach of the standard of care?
When something happens hardly at all, it's because it's successfully avoided in most cases and because those who practice it.
I mean, that could be the case. That might be. That's a nice theory. But it
Thank you.
also could be that
I
it's
came up
just,
with it all myself.
it could also just be that it's so, it's just something that doesn't happen very often, right? I mean, just, there's no real
Then
I
let's,
mean, if you're right, and I know you're not big on literature, I guess, but wouldn't we expect to see in the literature something that says, you know, the medical history and all the knowledge we have is that if something happens rarely, it's always a breach of the standard of care? That seems like a universal truth that I would expect to have seen somewhere other than just this case.
Justice Markman,
That's
I'm
not
sorry,
me.
Markman, Viviano, I don't know
That's
what
me.
I'm thinking.
Time more.
It's tough. Life is
Who
tough,
should be
but
more offended, Justice Markman or me?
Should we take a vote?
Yeah. All right, go ahead.
I'm
There'll
sorry.
be dissenting opinions on it.
The expert's opinion can be based entirely on knowledge, skill, and experience. And both Eller and Misra, and Edry, I keep calling it Misra, Eller and Edry say that over and over again, but then they do the double step of, well, absence of literature is especially important. Well, if literature is not necessary, then why is the absence of literature important? In these kinds of cases, the primary setting of the expert standard of care is that which the practitioner elucidates for the court. The support is there, and I explained to you why it is the support. Obviously, the second half of our expert's deposition was never taken, and we never had a Daubert hearing in that case. That's one of the questions here.
Would not your opinion then do away with the need for a Daubert hearing altogether? I
No.
mean, as long as the expert comes in and says, based on my experience and education and prior activity, I can tell you this is so rare, it's a breach of the standard of care.
That can be the expert's opinion. And if there was another case identical to the Danhoff case, that would probably work. But every case is different. One of the questions asked was, what forward-looking rule would you suggest? But there are so many things that can happen in medicine. It's not all medical malpractice either. The rule that you announced in this case will take, one of the cases I cited was a child custody case. Medical testimony comes in there, and expert testimony must be vetted.
Just to clear things up, plaintiff opposed a Daubert hearing in this case, right? Defendant requested one in a motion. Plaintiff opposed a Daubert hearing, and you're still not asking for a Daubert hearing in
No.
any of your appellate pleadings, correct?
No, but I'm no longer opposing one. If this court, in its discretion, believes that a further elucidation of Dr. Kobe's methodology and his means of supporting that methodology and arriving at a reasonable conclusion,
May I ask,
Please.
I don't want to interrupt
No,
you.
go right ahead.
Counsel, are you following the revisions to Federal Rule 702 that are due to be adopted by the Supreme Court this week?
I'm sorry, I'm not. I'm not.
Okay. And the Michigan State Bar has asked this court to amend our rule to conform to those changes. Are you aware of that?
I now am.
Okay.
I
well, then forget it.
apologize.
No big deal.
I should be keeping up with this stuff, but I'm not.
Well, I'm not sure it's not, it might well be relevant. I mean, the amendments might well be relevant, so it might be something, but we'll figure it out. Thank you.
And that's my presentation. I mean, Justice Sarla and Justice Viviano, Nee Markman, have helped me elucidate what I need. We need a direct reversal in this case. This expert had to have been good enough, maybe with a further Daubert opinion. But the lower courts need guidance. You do not have to have peer-reviewed medical literature in support of every plaintiff's standard of care expert testimony. And if there are no questions now, I'll scurry back to my table and come back for rebuttal. Thank you.
Good morning. I'm representing Dr. Fahim and Michigan Head and Spine Institute. He is a neurosurgeon that is a group of neurosurgeons. My name is Scott Sauerbeer, and actually I'm very flattered to be here because I've never had a judge or justice accommodate my schedule. But because I was supposed to be in trial today, you've all accommodated me so I can get back to trial. My trial is now in March though, so we'll bypass that. So I've looked at the list of questions that you really have, and I've tried to address them fairly succinctly. So as I understand what you wanted me or us to do is address the decisions in Edry versus Edelman and Elher versus Misra, and in particular the role of the supporting literature that you've just been having a conversation about. And then you wanted me to apply those principles to the Danhoff versus Daniel Fahim and Michigan Head and Spine case. I'm prepared to do that. So first, I address the overall concern of this entire bench and our entire court system, and that is to provide jurors reliable information. And it's a system of how do you do that? How can, not this court, but the lower courts, every court I go into in Wayne, Oakland, Macomb County, wrestles with these problems every day. And so what we have is really a set of guidelines. And it started with really probably Daubert versus Merrill Dow. And then 702 was amended, but 702 always looked for scientific information and backgrounds. Now it became more specific with the guidance of Daubert. And then we had 629.55, and the judges are to act as gatekeepers. They shall act as gatekeepers, and they shall exclude unreliable expert testimony and unproven expert theories. This is the whole basis, and this is the intent of the court. And this court, I'm sure, has seen back farther, even into the 1800s. When
Counsel, good morning, and I just kind of
Yes,
want to
Justice.
get, good morning and welcome. I just want to kind of, get things started, and what I want to really understand is exactly what your position is. Is your position that in order to establish standard of care, that in order for litigation to be able to commence, that for all intents and purposes, that it can't happen unless they're able to cite to peer review articles that are directly corresponding to the issue at hand? Is that the position that you're asking this court to take?
Absolutely not.
Okay, so can you expound upon that and
Of course.
let me understand exactly what the position is?
Of course. So I think that anybody that really takes that position doesn't understand the law or how to apply the law to these cases. So the first thing I would do, I would look to 2955. And 2955 gives you eight suggestions of things that you can do to perfect or prove your case has reliable information. And when you look at 2955, that is not the be-all and the end-all. Every case, from Daubert through Edry, each case says there are other things that you can do. And I can think of some, and I will provide you some ideas on that. But let me just answer your question more specifically, Justice Bernstein. So first of all, when you look at it, the 2955 says, the court shall consider all of the following factors. First one is whether the opinion and basis have been subjected to scientific testing and replication. All of these may not apply, and I wouldn't say that this would apply here from the information that we have. B, whether the opinion and its basis were subject to peer review publication. So that's your publication. So that is the B, or the number 2, out of the list of 8 things to think about doing. C says the existence and maintenance of generally accepted standards governing the application and interpretation of a methodology or technique.
Counsel, we're familiar with all the factors. I think Justice Bernstein's just trying to get to understand. Do you think that this court has given the factor that emphasizes the literature an oversized role in the test, which Daubert does not, but Davis-Frye did? Were we sort of stuck on Davis-Frye when we emphasized that factor?
I again, would firmly disagree with that position.
Oh, it wasn't a position, it was a question.
And that's why I was happy to go through either the Elher case or the Edry case, because in both of those cases, which would be like the foundation for what I'm here talking about, the courts have both said that while literature is important, other things should be consistent with it or in opposite. Sometimes there won't be any literature, and that's
Right.
why I was going to go through these 8 different
But
things.
we know all the 8. I think we're just trying to figure out whether that one's gotten an oversized role in our opinions that's causing some disruption in the lower courts. I mean, because there's not going to be, like you said, there's not going to be literature about everything. If a surgeon is eating Cheetos while doing surgery and leaves a bunch of Cheetos inside the patient, there's probably not going to be a bunch of peer-reviewed studies that say, don't put Cheetos in the patient, right? So, so that's why there are factors, and that's why there's not one that's, more important than others. And the question is only, have we somehow signaled to lower courts that one factor is more important than others?
I don't think that the courts consider that more important. It's a starting point. If you can find a scientific basis that answers your question with a group, and these articles aren't written by one person, they're usually written by a group of medical professors or experts on a subject.
So
And
if
I'm
it's-
very familiar. I have a very, I am a WebMD. I'm very qualified to read the medical literature.
I use
You just ask my
UpToDate.
doctors, they love it when I come in
I
having
use
read the
UpToDate and
literature.
PubMed.
So if it doesn't have an oversized role, in your opinion, then what happened in this case? Why was this expert not allowed to move forward?
With this case, first of all, Dr. Kobe came in as an expert. He had done 50 cases, 50 XLIF cases. By the own literature that he has participated in, he says a person is not an expert, or that article says, a person is not an expert in XLIF until they've done 100 cases. So he disqualifies himself without really talking about it. But, so what he did was, he didn't know what happened, except that there was an injury, as Justice Viviano was talking about, a rare injury. He took a strict liability approach, that if this injury occurs, I don't know what happened, but it's so rare, it can't happen unless somebody does something wrong. Well, there's plenty of explanations as what went wrong. I don't know whether the transcript reflects it, but I am involved in this case personally, and I know this woman had diverticulitis. I know the hole that was found was much larger than any tiny instrument they were using. So for him to say that is really, it would be a novel methodology for him to talk about that.
But isn't that something that could be hashed out at a Daubert hearing? I mean, I agree that a lot of that is important information, but wouldn't that be an appropriate way to sort of determine his credibility?
Well, it came up in deposition, and that was why I brought the motion to exclude him. So basically, what he did was he did no more than a guess. He did no more than a guess. He said because it's rare, something had to go wrong. Then he wrote his own affidavit, and as I've written to you, he agreed that the complications are rare. And then I pulled out, I could find 28 worldwide studies. If you want to look for peer-reviewed literature, I came up with 28 worldwide studies. They just don't do this in Detroit. They do this in Sweden, they do it in Japan, they do it all over the world. And the results are consistent in all of the studies that I prepared showing the rate of incidence around the world are the same or similar, very similar. Those are the
studies
statistics.
relied on by the trial court in making the decision?
Pardon, I didn't.
Were those studies that you found, were those part of the record and relied on by the trial court?
The trial court certainly saw them. I don't know exactly what the trial court relied upon.
They were submitted in support or in opposition to the motion? I mean, they were part of the
Oh,
motion
yeah.
pleadings?
Yeah, oh, yeah. Yeah, so, and,
Counsel, are you familiar with the changes that are coming to Federal Rule 702?
no, I think I need to be schooled on that one, too.
I think you're going to like them,
Uh-huh.
so, anyway, okay.
Okay, good, thank you,
I
though.
mean, and
But
the State Bar
as
of
soon as
Michigan
you
is
said that, I
recommending
made
that this
a
court.
mental
I
note.
will tell you, this is how that's lining up. The prosecutors and the civil plaintiffs don't like them, and the civil defendants and the criminal defense lawyers like them. That's how it's lining up.
It seems to me that all we're all trying to get to is what the truth is. And so let me just go on and tell you a couple of the other things that happened. The judge in the Danhoff case didn't rely just on literature. I mean, she got the ipse dixit statement from Dr. Kobe. And so there was a hearing. And actually, I thought it was a slam dunk. I was very disappointed when I thought she bent over backwards and said, no, come back, bring literature with you, bring something with you. She was begging him to bring something in addition to his opinion because I say so. She even referred him to, well, go read Edry. She said that to him. We came back the second time, and the court kept asking for more than just his opinion. She was hoping, I think, that he would come up with something in 2955. I had no problem in coming up with 2 affidavits of different neurosurgeons, uninvolved neurosurgeons, who said that, yes, this happens. It happens within the standard of practice. It happens rarely, and we don't like to see it, but it does happen. So when you really look at 2955, E through G, all of those options are there. The other thing that I sometimes do is when I look at a case, and I'm doing it right now, I've got 2 experts in a case I have up in Bay City, but I want somebody that has participated in the literature. And so I have gone to the bibliographies behind the literature, and I'm trying to find somebody that is willing to tell us or tell the jury about what this is, why it is, and what happens and why. That's better than any piece of literature I can find if I can find a true talking expert. But that's available to everybody, not just to the defendants. It's available to the plaintiffs. The other thing is that in the what's called the AANS, but the American Association of Neurological Surgeons, there are 3,500 experts listed in this country. And if you can't find one to match one of the criterion set forth in 2955, you shouldn't have brought the case. You should have looked at this case to begin with and not wait until you got to the end to say, oh, I can't prove my case. So that's another thought. But in short, Dr. Colby admitted his opinion was his personal belief. There's no evidence his opinion was generally accepted within the relevant community. There's no abuse of discretion on the court. She bent over backwards for him to provide some reliable information, and in accordance, given 2 shots, Dr. Colby could not find another neurosurgeon or opinion of any kind to support his beliefs. I think that the Dalbert case should be closed. I don't think any more action is needed on it. I don't think that if we were to go through a Dalbert hearing and go through each one of these things, I think I've pretty much answered them here for the court. There is nothing there that Dr. Colby has but his personal opinion. I appreciate your time this morning.
Thank you. You have about a minute and a half.
Thank you. Your Honor understands what's at stake here. This is not a case of literature versus no literature. This is a case of indirect literature not being sufficient. It is not a case where the defendant gets to say, jump this high, plaintiff. No, this high. No, this high. What the trial court needs to do is assess the methodology at which the opinion was arrived at, which was the appropriate methodology here, and whether the opinion that this particular incident was a breach of the standard of care is medically reasonable. Both of those exist in this case. When the trial court starts giving itself a promotion to determine what the correct medicine is, that's when we start getting into trouble.
Counsel, can I ask one follow-up question?
Please, ask as many as you like.
This idea that since it was extremely rare, that it was likely to be, or your expert said these things tend to be the unfortunate outcome of some form of a breach of the standard of care. Is that a general principle that applies to any type of surgery or medical procedure, or is that something your expert is saying only applies in this context?
The expert is only testifying about this case, and he is not cognizant of the legal ramifications of the use of that testimony. He is saying in this case, this is a breach of the standard of care, and its rarity gives me comfort and support in saying so. Thank you, Your
Thank you.
Honors.
Case will be submitted.